Okay, today is September 14th, 2010. This is Forensic Interviewing of Children. And this is really the first time we're going to talk about the substantive issues in the class. We've talked about Blackboard and the assignments and what's required of you over the past session and a third. Now we'll talk a little bit about the readings from Learning Module 1 and some of the things that this class is going to be about over the next 10 or 12 weeks. First of all, the idea here is to teach you strategies for forensic interviewing of children. The idea is to equip you with the skill set if you were called upon to interview children about abusive events, or any events for that matter, to equip you with the skill set to do that task competently, effectively, and in a way that's respectful of the child's ability. You'll see that throughout this class, among the most important aspects of what you learn is to be respectful of the child's ability. And that's not just social speak or social worker speak or, progressive thinking. For me as a prosecutor and a member of law enforcement, that's a critical idea too. And that's a critical mandate for me, because if I am respectful of the child's abilities, I'll get more information and better information. So if I take a very narrow, police-centered view, that I care about the case, I want to make sure I get the bad guy, I want to make sure I put him in jail. If those things are the only things that are important to me, and I have those kind of blinders on, it's still important to respect the kid and respect the kid's abilities, because the more I know about how a child thinks, how a child remembers stuff, how a child is able to express themselves, the more I respect the ability of the child, the more I understand about how they communicate at different stages of their development, the more information I get. The more information I get, the easier it is to look for corroboration. The more corroboration I get, the more likely it is I can prosecute someone who may be culpable or responsible for a crime or some other offense. So however you look at it, whatever your background, whatever your discipline, whatever your perspective, respecting the child is critical. And I don't mean so much just respecting the child because they're a child and they have human dignity and they're worthy of being treated with respect like we all are. I mean respect in the broader sense. Pay attention to their abilities. Don't ask them questions that are beyond their competence. Don't ask them questions that are beyond their developmental abilities. To do so is ultimately to undermine the quality of the information that we get. And the information that we get is important, isn't it? And I don't give a damn who you are, whether you're a DIFAS worker or a teacher, whether you're a hospital social worker or a physician, whether you're a deputy attorney general or a judge, whether you're a defense lawyer or a law guardian, I don't care who you are in the system. If you want to get good information from children, if you want to do your job well, if you want to get a successful outcome, then it relies upon the historical truth, doesn't it? What happened to this kid? Or the reliability, the credibility, the persuasiveness, the believability of what this child's memory communicates to us is important. It's important to the doctor, right? They got to treat the child. It's important to the social worker because they need to protect the child. It's important to the educator because they want to teach the child, protect that child. It's important to the hospital social worker and everyone else down the line. The historical truth, the fact of what really happened, is the basis for all of our actions, whatever our discipline is. Now, the actions that we take might be quite different. Child protection is going to try to protect that child, heal that child, treat that child, protect the other children who may be at risk, minimize the risk in the household or institution from the perhaps responsible parties. I don't care about that as a police officer or as a prosecutor or as a member of law enforcement. I respect that. My goal is to hold people responsible and punish them, not child protection. we both are interested in what the heck happened to the kid. Once we know, child protection has one goal, education has another goal, medicine has another goal, law enforcement has a different goal. But all of us base our actions, our response, on the historical truth of the believability of that child. If we don't believe that child, or we are skeptical of what that child's experience may have been, then we may not belong in that home. We may not have to compel someone to go to parenting classes. We may not have to place a child in a foster care situation. We may not have to treat a child for some medical issue if it really didn't happen, or if it didn't happen quite the way we think it may have happened. So the historical truth is important. The one place that it's not that important is in what discipline. I mean, it's still important, but it doesn't drive the discipline. And it's one of the first chapters that you touched upon in Kathleen Fowler's book, Interviewing Children About Sexual Abuse. What discipline, what professionals still can do their job and not completely know the historical truth? Psychology, what? Clinicians, psychologists, therapists. When you're treating trauma, right, when you're treating a child who is presenting with mental health issues, you want to stabilize that child, right? You want to treat them so that it is no longer a problem, whatever their mental health issue is. And while it's nice to know precisely what happened, it's not critical. It's more important to know how that child feels, what they believe happened, how they have processed whatever experiences they've had, how they express themselves. Whether that actually happened or not is helpful, but not critical to therapeutic treatment. Does that make sense? But nearly everywhere else, we want to know what the heck happened. And it is so hard in the area, especially of child sexual abuse, but physical abuse or anything a child experiences, to understand what they went through or what they experienced. And that's primarily because these are not miniature adults. They're not just little people who have all the abilities that we have. They're smaller than us. And they're less competent than us. They don't have the verbal skills, the cognitive skills. They don't have the skills of recollection. They're more vulnerable in certain contexts to suggestion and misleading questions. Now, as they develop, they become more resistant to some of the issues that plague the younger kids. But it is important to understand exactly how, to the best we can, how children develop and how we can respect their abilities and ask questions that have value and meaning, and not questions that are beyond the competence of the child. So that's what we'll talk about throughout the semester. Nearly everything that we discuss, or every learning project you do, or every discussion board you engage in, or every assignment you read, speaks to getting the most information and the highest quality information from children. And you'll see the theme throughout the scholarly articles and throughout the book readings. You'll see the theme over and over again about understanding how children develop and understanding what their abilities are and speaking to those abilities. You'll hear me later in this course say, rather simply, that children know more than they can tell. Kids, even real little kids, remember stuff really well. There are challenges in expressing that to us. Our challenge is in facilitating that expression, is helping them to express themselves in a way that doesn't mislead them. But it's in there. Oh, they remember. It's in their head, but it's hard for them to articulate. And the more distant the experience from the child's everyday experiences, the more difficult for them to say what the heck happened. So if a child's asked to describe, how a crane works at a construction site, that's going to be a little difficult because they don't see cranes every day. It's something beyond their normal experience. If they have to explain how the kids get on the school bus, or what happens when, you don't raise your hand in class, well, that's something that they've experienced multiple times. They have a social context for it. I give the crane example. When we talk about sexual abuse, there's something that is generally completely beyond the social experience of kids. Alex? Now, any questions about my little introduction? Professor Fowler, in Chapter 1, begins to talk about the kinds of interviewing strategies for kids who may have been sexually abused. Now, the focus in this forensic interviewing class is going to be on forensic interviewing of kids who may have been sexually abused, because that is the most difficult kind of forensic interview for a variety of reasons. Some which are obvious, and perhaps some which aren't so obvious. Excuse me. But number one, child sexual abuse is a serious crime in New Jersey. Sexual contact with children is a taboo in virtually all cultures and all over the world, on every continent. It is an emotionally charged issue, and it requires a certain amount of skill and a certain amount of delicacy when interviewing a child. If you can interview a child who may have been sexually abused, you likely can interview a child about nearly anything you experience. And my expertise is interviewing kids who may have been sexually abused. So it's through that lens that we will think about forensic interviewing of children. Professor Fowler starts out with presenting two models for interviewing kids who may have been sexually abused, although there are a few more that she mentions when she gets more specific. But you have forensic and clinical. Forensic and clinical. Well, the name of this class is Forensic Interviewing of Children. Forensic means related to legal proceedings. A forensic pathologist is a pathologist who works within the criminal justice system, who practices pathology within the legal system. Forensic interview is someone who interviews children who may wind up in the legal system. So the word forensic implies a connection to the legal process. A clinical interview does not imply a connection to the legal process. That implies some sort of treatment or therapy. Therapists are sometimes called clinicians. They work in a clinic or a clinical environment, a place where people go to get mental health treatment. They are called clinicians. Clinicians. As Professor Fowler points out, persons assessing a child for possible sexual abuse can be healthcare professionals, doctors, nurses, mental health professionals, but they are chiefly social workers, psychologists, psychiatrists, law enforcement, and sometimes lawyers, including prosecutors. She says, as I just said, forensic means belonging to the courts or to be used in legal proceedings. Kind of what I said a moment ago. One of the things she starts out with which is rather interesting because it's not a substantive issue. In other words, it's not really about how best to interview kids. But she points out that there is a tension between the two models. And that among some, forensic interviewing is more pure than clinical interviewing. There's this tension between forensic interviewing and clinical interviewing. And it begs the question, what's best for interviewing kids who may have been sexually abused? There are some competing views on the propriety of a clinical interview or a therapeutic interviewer providing legal testimony in the family courts, the criminal courts, or the civil courts. There is some conflict and some differences among even those in the mental health professions about how or if or under what circumstances therapists, psychologists, mental health professionals can also testify as an expert on behalf of the child or as to an issue that surrounds that child's experience. The American Professional Society on the Abuse of Children takes the most liberal view. Professor Fowler tells us about that. She says the same professional can play both forensic and clinical roles. But be aware when you switch roles. Now, the American Psychological Association, they have guidelines for child custody evaluation for divorce cases, and they specifically caution psychologists against assuming multiple roles in the same case. The American Academy of Child and Adolescent Psychiatry specifically states that the evaluator should not be the child's therapist. Now, the American Academy of Child and Adolescent Psychiatry takes the most restrictive view. Who cares? Why can't the child's therapist come into court and testify within a family court proceeding? Whether they have interviewed the child, whether the child made clear statements of abuse to them, and whether they have an opinion about the credibility of that or those statements. Go ahead.
I would say it's a positive and a negative to that. The positive would be that the child already has a rapport with the therapist, so therefore they would feel more comfortable in sharing their experience. But the negative is for the therapist, they may be more subjective for the child because they have a rapport with them, and they may not be in the best interest when you're trying to get information for sexual abuse. You need an objective party to get the information.
Excellent. Well put. Go ahead.
I would say for the therapists, they use their information just to I guess, kind of like treat the child for the trauma or the stigma they sustain within that sexual, quote unquote, sexual abuse, not to like really gain information to use against them or that report really. It's like the therapist is using that information just for that purpose, not to like manipulate it to want to bring the evidence to the court.
So on the one hand, there is a inherent tension or even a conflict in the role of the therapist or clinician. You offer that the clinician or therapist's goal is really not forensic, and it's treatment focused, and they are not trained in forensics, and they're not trained in the specifics of how to gather information in a forensic context. So that their background and their training and their goal and their purpose is quite different. So the way they gather this information may be influenced by that. Go ahead, Al.
When you said that why can't a therapist, go testify in court, what I feel is that therapists employ different methods of interviewing rather than forensic interviews. They might introduce puppets, they might use imaginary things, they might use suggestive things to open up the child, because their main goal is to get the child to calm down, like you said, to treat the child. And if they use methods that are not going to be able to hold up to testify, then they can't, it won't work.
Excellent. No, that's an excellent observation. And all three of them get to the heart of the matter, all three of your observations, but Alf is accurate too. Some of the strategies used in therapy, which are entirely appropriate, there's nothing wrong with that, are not the best kinds of strategies when you are subject to cross-examination in a criminal or civil case. The kinds of strategies that are used to build rapport with children, to help children express themselves, to treat children, make that therapist and that child ultimately vulnerable to cross-examination. Because when you introduce fantasy into an interview, it leaves some residue on the child, so to speak. That is, it can be argued that the child's statements were not credible or believable, but were the product of suggestion or fantasy or influenced by that kind of dialogue. So those are three reasons why it's difficult to wear both hats, that of clinician and that of forensic interviewer.
Also reinforcement. If they use reinforcement and they give prizes or candy or tell them how bright they are, the child can also embellish on what she remembers or what she thinks she remembers, and that's not accurate.
Yeah, the kind of reinforcement that you talk about might be a bit more acceptable in a therapeutic environment than it is in a forensic environment. And that's consistent with what Alp just said, and that is the strategies that therapists use, number one, can impact the persuasiveness of that child's recollection and take away or undermine some of its quality in the courtroom. And that's not ideal. I mean, if you're in a forensic context, you want the child's recollection to be as pristine as possible and unvarnished and unaffected. Yet, within the clinical world, there are other strategies used to make children feel at ease, to facilitate dialogue and exchange that are important but not good for court proceedings. The chapter by Fowler makes the distinction quite stark when she says, the number one priority for forensic interviewing is what? The interviewer has to be blank. Impartial or neutral. Same thing. I was looking for neutral. Impartial works for me too. They're synonyms. Impartiality and neutrality are critical for a forensic interviewer. They're not there to favor the kid. They're not there to favor the mom. They're not there to favor the family. They're not there to favor the case. Neutrality, impartiality, objectivity, lack of passion, lack of emotions are important. On the other hand, a therapist or a clinician, their role is one of what? For children or women or men or patients or clients? Go ahead. Go ahead. To advocate. Advocacy. They're there to advocate for their child or their patient or their man or their woman. In fact, that's the lifeblood of the therapeutic relationship, right? You go in there and meet with a clinician and you give them blind trust. You tell them all of your, hopefully in a good relationship, all of your thoughts and ideas and fantasies and secrets and beliefs and things that bug you, and you're there to open up. And that therapist on the other end of that relationship is there to listen, embrace, to help, to advocate, to bring you to a better place. They're not there to worry about the needs of the criminal justice system or the civil courts. Ultimately, they owe loyalty and to you, to the client. You have an observation? Okay. Go ahead.
I was just thinking that, like you mentioned, like an adult or a child, they feel this bond, this trust with their therapist, clinician, or whoever it is. But I guess it's the therapist gets to a point where they're like, well, when I hear something, when is it that I have to report it? Because a lot of times when they do, I mean, you're obligated, you have to report it, but the child may feel, the adult may feel like that trust is broken. They may go back. They may not want to open up and discuss further details about whatever it is that they, any kind of abuse, like sexual abuse. Or even if they go to trial, to court, and they see the person that they've trusted all this time, like the therapist, pretty much being out there, being cross-examined and asked all these questions, and pretty much all their thoughts is being put out there, everyone to listen, everyone in court to hear.
Well, you raised some excellent issues, and the last thing you said continues to make the argument that a clinician has no business being a witness in court on the issue of child sexual abuse or some other legal issue. Because you argue that the child can feel betrayed, that this is a special relationship, and whatever the noble potential outcome is, whatever the nobility of the therapist's presence in the court proceedings, the client doesn't see it that way, or many times won't see it that way, and will see it as a betrayal or as an exposition of their secrets. Well, if you don't get in the business of being a witness, then that's not likely to happen. There are a couple of other things that you raise that we discuss in the Children in Justice class. For example, the rules of confidentiality and how that impacts upon civil and criminal proceedings on whether therapists or clinicians have to testify. There are privileges that prevent, in most cases, the government or a private lawyer from compelling a therapist to testify against a client. And they're very powerful privileges. It doesn't happen very often. You see therapists testifying a lot, but they're not a therapist that the client or patient seeks out. A lot of times they're court-appointed therapists, and they're not really therapists, they're evaluators. So you're not going to get, it's a different dynamic there, and that's We're going to talk more about that in a minute. But when you're an evaluator, you're not providing therapy and treatment. You're evaluating. You got the same bunch of letters after your name. You have a very similar practice. In one case, you may be a therapist. In the other case, you may be an evaluator. But for this kid or this guy or this lady, you're an evaluator. We see those experts and therapists / evaluators testify all the time. But if you go to a doctor, a psychologist, or a social worker who's licensed in New Jersey, or you even go to a victim counselor in New Jersey, that person can never testify against you in court, with some very narrow exceptions, or for you in court. Well, they can testify for you if you waive confidentiality. There are evidentiary privileges that prevent that from happening. Now, if a child's under 13 or 12, then it's the parent that makes that decision. So you may see therapists testify in court in a one-on-one mental health relationship, but that's the exception. It may be because there was a waiver by the client themselves, which we'll talk about in Children in Justice, or the parent or caregiver made a waiver. But if that client doesn't want their sacred conversations discussed in court, they don't get discussed. Some very narrow exceptions. And that raises the third issue, and I'm going in reverse order from what you brought up. When you said, well, the client comes in there and tells the therapist all of their private feelings and all of their beliefs and all of their fantasies, and no one is supposed to say anything about that, and that's the engine that drives the clinical relationship. And you said, well, sometimes things get told and sometimes things have to be told. And that's true. There are certain compelling matters of law that require disclosure and what we call piercing the confidential relationship. Once in a while, that relationship gets pierced. And we talk a lot about that in Children in Justice, too. If a man goes to a psychologist and he talks about actively molesting his children, the psychologist has to report that to DYFS. And whether that can be used by the prosecutor or in other contexts you'll learn about in Children in Justice. But to the client, he's betrayed. He don't give a damn who you told. You told somebody. You'll read a case in Children in Justice called Tarasoff versus the Board of Regents of the University of California. And that's where this guy, Pajit Padar, was totally obsessed with this co-ed at UCLA named Tatiana. And he never really had a relationship with her, but he was obsessed with her. She was a classmate, and he told a psychologist when he went for mental health help at the university walk-in mental health center that he can't get this girl out of his mind. He loves her, and that if he can't have her, he's going to kill her. And you'll read about the case, and he was sent to the university police. They did some things. They went to the university police. They had him overnight for evaluation at a mental health facility, and some things happened. And then he was released, and a few days later he butchered Tatiana. After she was murdered, her parents, she was Tatiana Tarasoff. The Tarasoffs sued the University of California and a dozen other defendants. And the lesson of that case you'll see in Children in Justice is that confidentiality is pierced where there's the potential for grave bodily harm or grave harm or serious harm to a readily identifiable person. And we talk a lot about, what that means in that class. But yes, if you're in a therapeutic relationship and you're like, I'm pouring my heart out to you, these are all my fantasies and desires, you can't tell anybody. That's true. But there are a few exceptions. If one of the things you say is, when I go home, I'm going to kill my wife, I'm going to blow up the World Trade Center, well, then they're allowed to. But before Tarasov, it wasn't clear. This case was from the 1970s. Before that, it wasn't clear. In fact, that was the defense of California's university, the University of California. There was confidentiality. They had no right to betray that. And this was a civil lawsuit. There was a suit, what they call in tort, T-O-R-T. There was a civil lawsuit by the family for money damages for the loss of their daughter. So the way to handle that is, you need to tell the client and ask any clinic. Are there any clinicians in the house? People who ever practice mental health therapy? It is standard practice in the field to spend that first session talking about the relationship and the limits of it. And they say something like, listen, whatever you tell me is 100% confidential. Well, not really, but totally confidential unless there are a couple of things. If you tell me you're going to hurt somebody, I got to take action to make sure that person's safe and you don't hurt them. If you tell me you abused a child or you committed a crime like that, I have to report that. There's a number of things I have to report. So many clinicians tell the person up front that there are limits to confidentiality. And if you know that going in, that's good. Because it's important. It's an important part of the relationship that there be complete trust. And then people could get help. But that relationship isn't a very good one for being an objective person and doing an objective interview. And that's why I fall on the side of the bright line rule that people who provide therapy should not be called upon, nor should they make it their business to question children in an investigative manner about potential child abuse, especially child sexual abuse. Now, if that comes up in the therapeutic relationship, I don't say, therapist, you can't talk about it with the child. But when it's out there, you don't say, aha, I need to know more about this. I want to find out as much as I can so that I can share this information with someone else, with the court, or with DYFS. The role of a mental health professional who's providing treatment for a client should not be, in my view, to gather evidence. Even if it is solely for the protection of that client. Even if its nobility is not in dispute. It doesn't matter that the therapist just wants to help the child and protect them from future harm. It matters that they're not in the best position to be objective and neutral and ask the right kinds of questions. And they are extremely vulnerable to cross-examination. And the move has been towards forensic interviewers and specific evaluators within child custody cases, within the family courts. Now, those cases, those persons are typically psychologists or mental health professionals, but they wear the hat of evaluator, not treating clinician. There's a difference. Now, as Tiffany pointed out, one of the positives is, though, if you're treating a child or treating a person, you're in the best position to understand that child to make that child feel comfortable, to get them to open up. The one-shot custody evaluation or one-shot forensic interview is lacking when it comes to building trust and rapport. The positive of relying upon the mental health professional who's treating the child is they're more connected with that child. So they're more likely to get information. That child trusts them. And to open up about this, you need trust. And very few victims of child sexual exploitation trust anyone. So it is a challenge to build that kind of rapport with the child if you're a forensic interviewer or an evaluator over 1 or 2 sessions or 1 or 2 meetings. So there is that benefit to someone that the child is connected to. But the potential fallout in a forensic context, in a criminal or civil proceeding, is too problematic for me to recommend that kind of process. You are very vulnerable if you're a treating clinician and you take the witness stand on the issue of child sexual abuse in a criminal or a civil court. The cross-examination will be, even by the least experienced cross-examiner, quite emphatic. I mean, because there's so many areas that you can be attacked on. Because you're not objective. You know, we're here, my client sits here facing 20 years in prison. And they asked you to find out what happened? And then they'll take you through week after week of trying to help that child, believing that child. Isn't part of your philosophy to believe this child that no matter what she says? Now you can say no to that or dance around it, but you don't challenge the child, do you? Do you? No. Well, it's not in a clinical sense. You know, a mental health professional who's treating someone listens. They do a lot of listening, a lot of talking, a lot of listening. But they don't challenge. They don't get, like we started out by saying, they don't get too much into the historical truth or the facts. They want to hear what you have to say, and they want to deal with that. Now, as we go on and you see how forensic interviewing works, challenge might not be the right word, but there are ways to direct an inquiry into areas that might be suspicious or you might be skeptical of during a forensic interview. And that's good. One ought to explore alternative hypotheses. And we'll talk about that. You may feel, and I can feel that in a bit, that challenge is too strong a word. I mean, if we think of it in its strongest sense, you know, why did you go back in the room? No one wants to do that, but it may be relevant why a person went back in the room if they were sexually assaulted. If you're dealing with a teenager or something. And if that's an issue that needs clarification, you just don't leave it dangling. One needs to confront it and ask about it. Because if you don't, someone will. And it ain't going to be in the environment that this interview's in. And it's legitimate. Go ahead.
No, I just wanted to know that I do agree with you. I wanted to say that I do agree with you because with my experience with therapies and stuff like that, sometimes we request letters to find out, the status on how it goes, the therapy with the client, and we get back something talking really highly of the client. And we know the history. We know practically more truth than they know. They just go about what they say. And that's the reality for them, you know. If you ask them to testify in court, they're gonna go by what the client said, and sometimes, most of the time, they'll lie. They'll tell the therapist what they want their life to be. Now, the reality.
Yes, and that's a good observation. And again, it gets back to the fact that these people, by definition, there's nothing wrong with that kind of positive outlook, despite the fact that you know the real kid or the real mom or the real dad or the real caregiver, or you've seen more sides of them and more collateral aspects of their past. But, you know, their job is to advocate and to build up this person and to focus on positives. If you're treating somebody, you can't knock them down, man. You can't go, come on, man, why are you dressing like that? Why would you go back to that guy? Well, you ought to think twice about doing things like that. That, first of all, the client's not going to come back. Number two, you're not going to get anywhere with them. Very rarely do clinicians judge. And no matter how objectively unreasonable the behavior of the client is, they try to look for a positive aspect. Now, they don't just endorse crazy behavior, but they don't react like we might. You know, they put the question back to the client, they talk about the risks, they suggest other alternatives, they look at the reasons why. Why are you lighting off, firecrackers in the garage? Or why are you sleeping with dozens of people with unprotected sex? Why are you, driving your car 150 miles an hour? Why do you not call your mom? Whatever it is, whatever the behavior is, and they don't typically ask why, but they explore that area. I mean, even if it's negative or bad, they don't judge, they advocate. So you do get these kinds of reports from time to time, too, that focus on the positives. And it's another reason why it's not really well suited. Now, Professor Fowler argues that's okay. All of what you said is true, but that doesn't mean that Dr. Fowler from the University of Michigan, a brilliant social worker and clinician and academic, she can't change roles. But I don't know how you could really change roles in the middle of a relationship with a client. She says, and the APSAC says, well, when you know that you have to change roles, make sure you do. Make sure you're cognizant of that.
So, from your experience, how, talking about being vulnerable, how vulnerable is a diverse worker, knowing that often, it's not easy for us to maintain that be neutral or impartial, because we've always been trying to kind of believe the child, especially when it comes to sexual abuse cases, where there may not be evidence. The child may have been touched, but you don't have evidence, and sometimes, management or powers that be are kind of pushing you to substantiate that case, even though when you don't have the evidence. So from your experience, how vulnerable are we when it comes to court as far as testifying?
Yeah, I mean, there are some similarities between what a child protective service worker does and the clinician does. But I think they're different enough that the same kinds of issues that arise with therapists in the courtroom don't really arise from DYFS workers. In a way, you kind of advocate for the children, but you advocate for the family. You advocate for minimizing risk. You're not a private person who's contracted by the child or the parent or the client. The relationship between you and the child is imposed by circumstance, and you don't spend weeks and months trying to treat or heal that child's trauma. Now, I understand you're advocates, but you're in a way you're an advocate for the child, but you're an advocate for safety, for reduction of harm, for minimization of risk. Not only for this child, but for the other kids in the house. You're an advocate for stability, right? You're an advocate for normalcy. You're an advocate for education. You're an advocate for competence within the family or within an institution, whatever DYFS you're with. And I know relationships are built with the children that you represent or advocate for, but it's a fundamentally, I think, different kind of relationship than a therapist-client relationship. But nevertheless, when a division worker takes the stand, you're fair game on that point. If you're the one who gathered the information or interviewed the child, a fair area of inquiry is about your relationship with the child, whether you have spent, how long you've had that relationship with the child, what your feelings are about the child, whether you like the child, look, people are allowed to testify, and they have biases and interests, and, they are connected to someone in the case, and that comes out in every case. Parents testify. Obviously, they love their children. We don't throw them out of the courtroom and go, they're easy to cross-examine. But we're talking about a very specific endeavor. We're talking about interviewing kids for legal proceedings. DYFS doesn't do that. You interview kids, and it winds up in court, but that's not the point of it, right? That's a collateral consequence. It happens, but that's not the point of it. And the question becomes, do we rely, and this is what the dichotomy is, this is what this chapter 1's about. Should we allow, when we want to find out what happened, should we dispatch therapists who are treating the kids to find out what happened? Or should we use someone who's just a forensic interviewer? Who do we use to question the child about whether they were molested so that we could put the bad guy in jail? Or we could sue in the civil court? Or we can change custody? Okay? Who do we use to do that? Well,
DYFS does. We're not permitted to interview children of sexual abuse.
what county are you from? Monmouth, yeah.
But sometimes, they will ask you, I think the kind of rule of thumb is, you may be the first person to talk to that child.
Yeah,
At the moment the child says something, then you may have to end that interview to kind of go to the next level.
As soon as the child makes any kind of remarks that there's sexual abuse, that interview ends for us. And we call the police, they call the prosecutor's office, and they're the first people to interview that child.
Now, what you're referring to are relationships in particular communities where a certain class of cases, the division defers to the multidisciplinary team or the county prosecutor's office to conduct that investigative interview. I've been doing that for 20 years in Passaic County, and we do the same thing. Nevertheless, Thaddeus is onto something here, because even in Monmouth and Passaic and all the progressive counties in this state, there are some cases we don't take for a variety of reasons. And Thaddeus says, hey, there's a lot of, I call them look and sees. And I know that's the bane of the DYFS worker. And I know that you guys hate that.
Yes, we do.
I know it. And I don't blame you. On the other hand, it's a necessary part of what we do. That we just, we have 8 detectives, and I know you guys have 20, 25, 30 person caseloads or client caseloads, but we can't do a complete forensic interview and investigation with 6 people in a 500,000 person community like Passaic County. Forget about Essex and other large counties. So you get these kind of things. And we do it in my county, not when there's a clear statement. If it's ambiguous or vague or anonymous or the system is skeptical, we're like, well, go to the school or talk to the child. And I'd like not to do that, but we do, and everyone does it. I'm sure it even happens in Monmouth. And that's okay, because it's just, I have a remedy for that, but that's the way it is right now. The other time, though, is there's a class of cases, even in progressive counties, where the prosecutor's office or the team doesn't even get involved, where, maybe it's a lewdness or a sibling incest case or, something that the prosecutor or the team that doesn't investigate. It's a 13-year-old on a 10-year-old, and, it might not be worthy of juvenile delinquency prosecution, but it's serious. It's about sexual abuse, isn't it? DYFS workers need to ask the 10-year-old about the 13-year-old brother, or the 13-year-old cousin, or the 13-year-old neighbor sometimes. If it's in a babysitting context, if it's a DYFS jurisdiction case. And the prosecutor's office may not be involved there at all. And the division does the complete interview. My goal is, and my hope is, over the next 2 years, as my career ends, and I've been saying it to these classes here since 1999, and we have the right set of circumstances here. We have a quick-to-action governor, like him or don't like him. He does things fast and decisively. And you have a commissioner of children and families who's outstanding and grew up in the trenches and gets it, Allison Blake, and it can happen. And the idea is that I've been floating for 10 years now and under 3 administrations. And New Jersey is a good state to do this. You got 21 counties, so you have 21 DYFS areas, if you will. And every county has its. We talked the other day about, was there 3 in Hudson? 4 in Hudson? 4 in Hudson, 3 in Passaic, 8 in Essex. How many in Monmouth? 2 in Monmouth. It's like Passaic County. 2 in Passaic County. There's no reason why, in a collaborative arrangement between the hospitals, the Child Advocacy Center, the prosecutor's office, and DYFS, that each DYFS office, let's say the 4 in Hudson, for example, each DYFS office has child protection specialists or intake workers or the investigators, right? Is there a soup here from Hudson? Gonzalez. How many intake workers are under your supervision or in your district office?
I have 4, but there's a total of
24 intake workers, and you're only talking about one of the 4 district offices? 20. What district office? What's the number? District Office West? Hudson West? 24, this is what I'm talking about. Well, give or take. 19. We'll take 19. 19 child protection specialist intake workers in Hudson West. Take 4 of those. Let's go with 24. I like the number better. Works out even. Would you ever have 24 when you were at full strength? Yeah. Let's say it's full strength. 24 workers in Hudson West who are intake workers. Okay? They're the investigators for the division, right? They go out and find out what happened. Then they pass it on to permanency, I guess, or whoever's next in line. Out of those 24 in Hudson West, we hire 4 people to be child interview specialists. Or 5, or 3. I think 4 is about right, but who knows what the number is. Maybe 5 is better. But let's say 4 for even numbers. So there's 24 child protection specialists / intake workers. 4 of them are highly trained child interview specialists. They do all of the child interviews in Hudson West. Every one of them. Every one of them. For the prosecutor's office, for any case that comes through where it's alleged that a child may have been sexually abused. Now, you're doing them anyway, right? Now, some of them go to the prosecutor's office and the detectives do the interview. But what I'm saying is you take 4 or 5 or 6 of them. So let's say you take 6. That leaves 18. The other 18 do all the other work. The interviews are done by the 6 child interview specialists. And the prosecutor's office and the Child Advocacy Center and the local hospital. Everybody's on board with the hiring decision too. These 6 persons are vetted and they do the interviews in Hudson West. Every one of them. There's no more look and sees. There's no more, well, it's a 13-year-old and an 11-year-old. There's no more, we can't take it today, come back tomorrow. Come back the next day. Come back on Monday because the child's not in danger. Those 6 workers, they're investigative interviewers, they're intake workers, but they do the forensic interviews in the Hudson West District area. And the prosecutor agrees because they'll take part in the hiring process, in the vetting. I mean, they'll be part of the training and the hiring of these people. They will accept those interviews for prosecution. Those interviews will be accepted by the DAG. So rather than have all 24 people just doing everything, or some of it if it winds up in the prosecutor's office, there's a subset of child protection, child intake workers who do forensic interviews. And in all 21 counties, in all district offices, DYFS will have child interview specialists. And they will interview the children at the Child Advocacy Center. So, where there's a child who is at public school 26, right? And you have a disclosure or a reasonable suspicion that that child was abused. This is part 2. That child gets interviewed by one of the 6 interviewers. They get a comprehensive interview, and they get interviewed at the Child Advocacy Center. No more interviews in classrooms with the principal or the vice principal, the nurse standing over your shoulder. No more interviews in the basement of the school. No more interviews in the library as the students walk by and peer in the window. Wouldn't that be nice? Now, there are 2 things that have to happen there. You need to create buy-in among the prosecutors. You need to create buy-in among child protection. I don't think there's too much that child protection would object to there. Now, the prosecutors may be more of a tough sell, but when they realize that, that's less people that they have to commit to interviewing, that's less overtime, and that they have a stake in the training and the hiring and the supervision of these folks, although they'll be DYFS employees, they may be a lot more likely to accept that, especially since that's one less person that has to go out between 4:30 and 8:30 in the morning. And nearly all prosecutors' offices have immediate response, other than Essex. I mean, nearly all prosecutors' offices in the state, if it's a serious case that fits their intake protocol, go out after hours. Well, that's one less person you'll have to pay. That person will get interviewed by Child Protection. In Passaic County, we have 2 district offices. In Monmouth, they have 2 district offices. Maybe in Northern Passaic, there's... Well, who's here from Northern Passaic? Central Passaic? How many... Yeah.
We have full staff.
Yeah.
We will have 25, but right now we have
25. Give me 5 of those people to be child interview specialists. Morning, noon, and night, 7 days a week, 24 hours a day, 12 months a year. When a kid may have been sexually abused, a child interview specialist interviews them. They're going to be working anyway.
Working a lot.
Well, you're working a lot right now, aren't you? You got to interview these kids anyway, don't you?
Because you know what it is? It's when it comes to sexual, to me, it kind of pulls on my heartstrings because it's something like, it's very delicate. It's very delicate. It's very emotional. Yeah, and you keep hearing more, it's more extreme situations. I think I've heard it all, and we'll get a new case, it's like, I cannot believe this. So,
Well, the point is that you'll have specially trained people that will interview the kids that are trained to be objective and neutral and to listen and to reduce misleading questions and to reduce suggestive questions. Ultimately, you're going to wind up with better outcomes in the family court and the civil court and the criminal courts. There's no doubt about it, than this kind of disjointed way we do this now. I'm sorry, go ahead.
No, I was going to say, I think when they came up with the child advocacy unit, that was kind of the thought process. But I think somewhere down the line, that wasn't, that's not the result. But I think when child advocacy, and I think each county, if I'm not mistaken, kind of have the CAC unit, they were supposed to handle those tough, complex, sex abuse or physical abuse kind of cases. I mean, they still do. But the whole, but I also think that, like in our county, I just think that the prosecutors sometimes they have much influence on even the child advocacy workers because, of the same problem we have in the local office. They don't have enough manpower. When are they going to go out? They're not available to go out right now. And then they limit the number of cases they can get. Like we just revised our protocol with the Child Advocacy Center that in the local offices, the rule is you can have more than 8 referrals a month, for the investigators, at most, 8. But I think with our child advocates, we now come up with not have more than 6. And being that is a busy county, by the third week, most of them already have reached that number. And then the local offices are forced to handle those cases that the CAC people cannot handle. So the commitment of the resources is not quite there, most of the time, to handle such amount of cases in busy counties.
Well, you listen to the rest of this semester and see if you agree with me at the end of the class that every kid in this state, whether you live in Bergen County or Salem County, whether you live in Newark or Patterson or Short Hills or Franklin Lakes, ought to get the same kind of objective, neutral, and immediate interview. You'll see how important it is to respond immediately for a million different reasons. And that's not what happens now. Even in the most progressive counties, it's not what happens now. Maybe 1 out of 5 cases gets that kind of immediate response that it deserves. Not because of indifference, but because of competing interests and competing issues. What? The media? Oh, well, the media gets treated like the media gets treated now. I mean, that things wouldn't change because we're interviewing more kids. And more consistently. Why should you get a better interview, arguably, in Monmouth or Passaic County than you do in Essex or Camden County? Why? The division has to, if the prosecutor's offices shut their doors, pack their bags, and all move to Oklahoma, you'd still have to investigate these cases, Dyfus. You still have to go out. There's a mandate. Our case intake is discretionary. But more importantly, there ought to be the same kind of level of response no matter where you are. Around the country, we're moving towards credentialing forensic interviewers. And the good news is the requirements are minimal, but the thought is that it's important that the persons that we rely on to interview kids who may have been sexually or physically abused have a certain level of competence. And it's not somebody who got moved from ARC last week because they got yelled at, or they don't like the guy who sits next to them, and there's an opening in the intake, and Yeah, she's cool, I like her, and I move over there, and then next thing you know, they're an intake worker.
That's what happens. That's what happens. That's what happens, unfortunately.
Well, the people that ought not happen. The people that do this ought to want to do it. It's hard, no doubt about it. It pulls out, you're not good, and I'm not good. And maybe a third of you aren't good. That doesn't mean you can't be a great DIFUS worker, but it means that you may not be a forensic interviewer. And let me tell you something, at the end of this class, always 2 or 3 people go, you have any openings? This seems like a fascinating career. Well, there is no career right now. I want to turn it into a career. Well, in Monmouth there is, and in Passaic and Essex there is. There's a few counties who have forensic interview specialists, but not many. But it could be. And not because I want to wedge some new career path into the economy. It's because it's necessary. It's necessary. But to the suggestion that this kind of work, and I heard it when I first proposed this in '97 at the prosecutor level, and we hired a couple of forensic interview specialists. People said, how could you do that every day, all day? But there's some people who can do that, you know. How can you be a policeman every day? How can you fight fires every day? You know, I mean, some people got it. Not me, man. I won't do it, but some people do. You know, and some people love kids enough and love, you know, interviewing people and being involved in the criminal justice system that they want to do that kind of thing. I mean, I go around the state educating and training people how to do forensic interviews with the Finding Words Project, and every time in the past 8 years that we've done this, every time, now we only train 40 people at a time, every time we've trained people, I find 2 or 3 superstars. The rest of the people are okay, and they do okay, but I find 2 or 3 that I just go, wow, I wish this was a field, because that lady or that guy's got it. You know, it's like going to visit friends in the Dominican Republic and seeing a kid who's got a 98-mile-an-hour curveball. That person's special. And it's too bad you can't, you know, find a role for them to help kids. And I see it every time. Every time we do these trainings, I see 2, maybe 3 people who are gifted. And they don't know anything. Most of the people who come in, they don't do this. You know, it's not like we train forensic interviewers who do this on a daily basis. They're DIFUS workers and cops and prosecutors and mental health professionals. You know, and it's not always the DIFUS workers or the mental health professionals. Every now and then there's a prosecutor who's like, wow, they're pretty talented. If they weren't a prosecutor, they could be a good forensic interviewer. And, you know, at the end of the day, they're the people who can make the difference between a finding of abuse or neglect and protecting that kid and rehabilitating that family or taking some bad guy off the street. I mean, I joined the sexual abuse unit, the child abuse unit in 1992. You know, we made, when I came, 3 or 4 arrests a year. We make close to 100 arrests a year now. And if I dismissed 20 cases in whatever that is, 18 years, that's a lot. They plead guilty, they go to trial, we win, we lose. Most of the time we win. Sometimes we lose, and most of the time they're convicted. But you got to prepare a good case product. And the way to do that is to have highly trained people. So we'll see what the future holds. Professor Fowler talks in the second part of your readings about the different models. There's the forensic model. We talked about forensic and clinical, but she also talks about the in chapter 3. The models for assessing child abuse, and she gets into a little more detail. The child interview model, she says that one is the most prevalent. Although I think most progressive areas in this country are moving towards the joint investigation model. The child interview model places most of the investigative effort upon the child. It's all about interviewing the kid. And that's a critical part of the investigation, but there's more to it than that. And that's why the joint investigation model, I believe, is the ideal. The child interview model usually involves a single interview with the child. The joint investigation model can also use a single interview, but there are multiple parties involved, typically child protection and law enforcement, sometimes the municipal police and the prosecutor's office, as well as DYFS or child protection are involved. Professor Fowler pays some respect to this parent-child interaction model. You know, I'm not sure what that is, but apparently there's some... Well, I know what it is, but I'm not so sure what its credibility is. Professor Fowler says the second source of this model derives from divorce cases. Often evaluators attempt to assess the quality of parent-child relationships in divorce when there are custody and visitation disputes. They look at how parents and children interact. Now look, if you had a hidden camera in the house and it recorded these things, you know, maybe we can draw some valid conclusions about abuse or neglect. And if it does have some validity, I would suggest that it's probably where there's physical abuse, where you can watch how kids react to caregivers and draw conclusions. And, you know, I'm not sure how the evaluators can draw good conclusions in an artificial environment. You know, if they leave, I'm not sure. What does she say about how do these parents and kids get together? They put them in a room or something?
They watch from a two-way mirror or with a camera. They
Right, but it's in some artificial controlled environment. Yeah. I'm not feeling that. I'm not. Again, I could see how it might be helpful maybe in a physical abuse or a battered child context, but sexual abuse is based upon assumptions that really don't apply. You know, it reminds me of the defense lawyers who want to bring in for the jury, you know, pictures of the teenage girl sitting on dad's lap at a picnic, smiling for the camera, writing a card on Father's Day, "I love you so much," going on vacation and, you know, rafting with dad or inner tubing and, you know, producing all of these bits of evidence of tremendous affection for their father. You know, as if that is inconsistent with being abused. And it's not. I mean, that's, you know, why we have to put experts on. It has some superficial appeal. But to believe that that is evidence that undermines the allegation of abuse is to not understand incest or intrafamilial abuse. I mean, that doesn't mean they don't love dad or don't like dad. In fact, one of the most difficult aspects of these investigations is overcoming the loyalty and the affection and the the paternal love and affection that is part of many families. You know, I mean, as the observation is often made, the child still loves dad, she just wants it to stop. That's all. She doesn't want him to go to jail. She doesn't want to take him out of the house. She doesn't want to see mom crying. She don't want to see her brothers and sisters picking on her and calling her names. And just stop it. And then I can go rafting again and sit on his lap and write him cards, and he'll be my dad, not this other person. So I'm not sure, getting back to this model, how you put a kid in a room and watch how dad or mom or whoever interacts when it comes to sexual abuse. Professor Fowler says when clinicians apply this model to sexual abuse, they assumed victims and offenders would engage in sexualized interaction while being observed, or that the child would show fear or avoid contact with the sexually abusive parent.
Well, if the child would lower its eyes and not have eye contact, they could be really angry with their parents.
Right.
Have eye contact.
Writers disagree about the significance and meaning of various reactions. She quotes Gardner here, who was a charlatan and he was a person who coined the term parental alienation syndrome and wrote a bunch of vanity published books about those kinds of things. But Professor Fowler is, she's very objective, and she puts in all of the stuff out there to be fair and objective. She writes, and accurately so, in terms of utility, the concern is whether mental health professionals can reliably detect sexually abusive and non-abusive relationships. With regard to ethics, the concern is the impact of these parent-child encounters on the child, especially if the child has been sexually abused. It brings up the other issue. If she is being sexually abused, is it a good idea to put him in this room and watch them interact? Although some research has been conducted, the findings are not supportive of this model. Lastly, she points out the comprehensive assessment model. And that's kind of the clinical model. And that's not really what we use in a forensic context, but you might use that in the family court. That's where you have a professional or a group of professionals gather information from the child and from collateral witnesses over multiple sessions. Now, you could do that forensically. You don't have to be a therapist. You could have multiple sessions with a child, and you could have another professional, the mental health professional. You could have the medical professional, the police professional, gather information. So it bears a relationship to the joint investigation model, except the comprehensive assessment model typically involves more than one interview with the child. Most joint investigation models, it's one and done, single interview with the child, which is not ideal, but arguably good enough. Excuse me. Any questions about? Yeah, Al, go ahead.
With the work that gets done in the child advocacy centers, would it fall best under the comprehensive assessment model?
Well, not necessarily, because it's close. The Child Advocacy Center is more of the joint investigation model, although the regional diagnostic centers in New Jersey are more of the comprehensive assessment model. And it depends upon what your definition is and what your community considers the role of the Child Advocacy Center. But in my experience, in my community, the Child Advocacy Center is more of a investigative place that's done jointly rather than a comprehensive assessment model. Now, at Winona's House or NJ Cares in Camden County, Audrey Hepburn Children's House in Bergen County, then there's the one in New Brunswick with St. Peter's and Robert Wood Johnson there, Dorothy B. Hirsch Center. Those places do they have clinicians, they do multiple interviews, they interview collaterals, they come up with an assessment and a plan, they contract with DYFS. So they would be more of a comprehensive assessment model. Anyone else? Go ahead.
From the forensic aspect, is there a limit as to how many times the child will be interviewed? Like when the child is like the prosecutor or
No, there's not a limit. However, most forensic interviews and most programs recommend a single interview for some practical reasons. Number one, in many cases you're going to get enough information from that interview to take action. In nearly all cases, there are missing pieces to that recollection. So one can't have a protocol, if you're a forensic interview center or you do forensic interviews, whereby you bring the child back when there's new information. The nature of disclosure is that it is piecemeal and incremental, and you're never going to get the whole story the first time. But you will get enough of it to take action, sometimes a significant part of it. Which takes us to the next point. Number one, you usually get enough, so it's not that relevant, it's not that important to go back. But number two, most places don't have the resources. If you're interviewing 150 children a month, once, if you had to interview them multiple times, you can interview 1,000 kids a month. Well, if you interview them 3 times, that would be, almost 700, 800 kids. It's not practical to interview kids on multiple occasions. Nor does it have enough value, and that was my first point. You get most of it the first time. You don't get all of it. And sometimes there are important details that are missing. But you get enough of it for child protection or law enforcement to take action. And to do it any other way would require unlimited resources. Because kids tell more and more as time goes on. The model that we have now kind of works where that small subset of cases that needs multiple interviews, you refer to a regional diagnostic center or to a comprehensive treatment team. And then the kid will get interviewed on multiple occasions.
That's what kind of happened with one of my kids. The thing about it is that she kind of recanted most of the stuff she said initially. That's why I asked, was there like a limit as to how many times the child should be?
Yeah, I don't know. Well, the thing is, you want to minimize the number of interviews too. That's one of the points of multidisciplinary approach to child abuse investigations. But, the fact that there were multiple interviews, I don't think is irrelevant to the recantation. That child would recant. Somebody's going to have to ask her again. It's going to come up again, and the fact that she recanted ought to be known. We can't say, aha, if we didn't interview her again, we would have never had that, everything would have been better. No, then you would have had a kid who wanted to recant, who was trapped and was recanting, and we just didn't know about it. And then if the case ever came to court, then we'd know about it. Nobody wants to know about it the day of court. Now, you had a couple of articles to read. The one that I want to just highlight one or two things is the article about the history of suggestibility. And one of the more interesting characters in modern European history was a man named Franz Mesmer. Now, he lived in the 18th century in France, shortly before the rise of Napoleon and shortly before the French Revolution. It was the last days of the monarchy when this Franz Anton Mesmer would go around the countryside in these, and this is what made him noteworthy and interesting, in these long flowing robes with stars and moons, and he had this wand that he would use to readjust the animal magnetism of his subjects. And the reason why he became a celebrity in France during the reign of Marie Antoinette was the fact that lots of people were reporting that they were healed or helped by Franz Mesmer. He would wear these silk robes and fix his eyes upon them and pass his hands over their bodies and touch them with the iron wand, and they would have their animal magnetism or their magnetism adjusted. And lots of people, including adults and kids, felt that they were healed. Well, as he became more and more popular and more well-known, not only in the countryside, but as word spread back to Paris and the capital, the government began to become suspicious of this person. Anytime there's an average person who captures the imagination of the people and begins to wield power, governments get concerned, whether it be Jesus Christ or Rasputin or Franz Mesmer. So they did an investigation into Mesmer just to find out what the heck was going on here. And their conclusion was rather simple. That is that people genuinely felt better, some people genuinely felt better, but it was merely the product of suggestion. And suggestion is a powerful tonic. It really is. To this day, people use the power of suggestion to feel better. And for a variety of different tasks. But because Mesmer was so I think of the right word, because he was so flamboyant, and because he would stare into their eyes and wave this wand and recite these incantations, the thought was that he was also hypnotizing them. In fact, hypnosis is, by definition, a suggestive therapy. Right? It's all about suggestion. So we know that suggestion can alter the mind, right? It can alter people's perceptions. There's no doubt about that. The term mesmerized as a synonym for hypnotized. When somebody has got a blank stare and they're taken over by a TV show, or they're really obsessed with something, or they're totally focused on something. Yeah. Franz Mesmer. That's where we get the term mesmerized, from Franz Mesmer. Now, the article by Suzanne Davis goes through all of the uses of and investigations into suggestion throughout the years. In fact, suggestion is not a bad thing. Hypnotic suggestion is used today, and it was used in the past to respond to a variety of different ailments. There wasn't a lot of investigation or research into the impact of suggestion on children, especially children in the court system. But throughout the years, there was plenty of generic research on suggestion, especially in the field of hypnosis. There were a couple of French doctors in the 19th century who began to question kids' recollections because of suggestibility. Especially this French doctor named Fournier, who said that many common childhood medical conditions were misinterpreted by mothers as sexual abuse. And then they would question their kids about sexual abuse. And they felt, now remember, this is in the 19th century, this is in the 1800s. They felt that there were false allegations against respected community members because mothers suggested these abuse details to their kids. And you know, not much has changed in a few hundred years. Because you hear the same kinds of things now. We're going to talk in depth about suggestion in this class, what it's capable of doing and what it's not capable of doing, where it makes sense and where it doesn't make sense. About the circumstances in which it can impact upon a child's memory, and at the circumstances where it's unlikely to impact the child's memory. You had Bernheim late in the 19th century, another French doctor who started testing kids. And he coined the term retroactive hallucination, which is kind of like what we call false memory today. And this is the first time they began to look at children who were involved in the legal system or children's eyewitness testimony. He argued that child witnesses, if they succumbed to suggestion, did so because of memory confusion resulting from social pressure rather than deliberate lying. And we know that that's true today, that can happen. And the important distinction to take away from this is that it's unlikely to be deliberate deception by the child. It's more likely to be confusion from social pressure. So Bernheim was ahead of his time. And then in the 20th century, you had other folks, Baron Donk, the most famous of which, in 1911, conducted a number of experiments of children's eyewitness testimony. But Verendonk was kind of like someone we'll study later in the course called Stephen Ceci and Maggie Bruck and these folks. But even Ceci and Bruck are far more objective than Verendonk. I mean, he simply concluded that children were not reliable witnesses, and they had no place in the courtroom. He felt they were highly suggestible and unable to give accurate testimony. So the reason I gave you this article the first week is to begin to introduce you to the concept of suggestibility in children. Because that's the big thing a forensic interviewer needs to worry about. Interviewing a child while minimizing leading and suggestive questions is a difficult challenge, but it can be done. We're going to take a look later at modern suggestibility research and what we've learned from that and how we can take those lessons and raise our case practice. But suggestibility is such an important issue that it needs to be introduced in week one, it needs to be thought about, and we need to realize that there is an historical context to children and suggestibility. That this is something that professionals have worried about for centuries. And we, too, in 2010, need to respect the fact that kids, in certain contexts, can have their recollections distorted by the kinds of questions we ask. Any questions about that? Okay. Don't forget to do Learning Module 2. Or begin that. You have whatever, 2 weeks or to the 27th to do it. Pay attention to those due dates. Pay attention to the discussion board due dates. And I'll see you here next Tuesday.